Good evening. My name is Ashley Carter, and I'm a senior staff attorney and deputy director of our Justice Project at Advancement Project National Office. Advancement Project is a national racial justice organization based in Washington, D.C., and our work is focused on supporting grassroots organizing groups around the country. We focus on voting rights, ending the school-to-prison pipeline, mass incarceration, policing, and immigration issues. We bring strategic communications, legal, and community organizing support. I want to start by thanking everyone for being here. This is a really wonderful opportunity for us to gather and hear from our partners around the country, to hear about the work that they're doing to address issues of mass incarceration, and to navigate strategies for dismantling oppressive systems. We are in a particularly poignant moment in our country where we're seeing the continued oppression of Black, brown, and poor people by systems of policing, by jails and prisons, and by the vestiges of white supremacy across the country. And while we're seeing all of these challenges and oppressive regimes, we're also seeing the resilience and the strength of communities. And that's what we hope to capitalize on and to showcase tonight in our forum. Our goal is for people who are directly impacted and their families to walk away feeling empowered with tools to navigate the criminal legal system as they work to keep their people free. And with that, I want to just thank everyone again for joining us, and we can start our program.
Hi, my name is Inez Bordeaux. I am an organizer with the Close the Workhouse campaign. I'm also manager of community collaborations at Arch City Defenders. Arch City Defenders is a holistic legal firm in the St. Louis area that focuses on civil rights and advocacy. And Arch City Defenders is one of the 3 organizations that makes up the Close the Workhouse campaign. It's Arch City Defenders, the St. Louis chapter of the Bail Project in Action St. Louis. And the Close the Workhouse campaign is a campaign that's been around for about 4 years. The Workhouse is a jail in St. Louis, also known as the Medium Security Institute, that predominantly houses Black and poor people in inhumane, unconstitutional conditions. The goals of the Close the Workhouse campaign have really been threefold for the 4 years that the campaign has existed. One, it wants to close the jail, period, because the facility is inhumane and unconstitutional. The other goal of the campaign is to end cash bail. The Workhouse would not exist without being able to cage poor, mostly Black people who can't afford to buy their freedom. And then the other goal of the campaign is to do what we call re-envisioning public safety. That means divesting from the failed arrest and incarcerate model, divesting from that and investing in the things that actually makes our community safe, like affordable housing, childcare, mental health services, access to resources. So thank you all so much for having me today. I'm very excited for this conversation. And I'm going to pass it over to Erin.
Thank you. So good evening, everyone. My name is Erin Keith. I'm a staff attorney at the Detroit Justice Center. At DJC, we work on various issues. We're an abolitionist organization that seeks to create what we call just cities, fair cities, cities that have fully healed and been remedied from the ramifications of mass incarceration. So what does that look like? Well, we work on various issues for indigent individuals and formerly incarcerated individuals, things like litigating low-level misdemeanor offenses, such as traffic infractions that should not be criminalized, things like helping with family reunification for individuals who are coming out of the prison system. So that looks like helping getting back owed child support forgiven, helping create parenting time or custody arrangements for individuals who may not have had access to their kids and may have not been able to parent during their time away. And then also helping with indigent, other indigent defense issues such as like evictions, and just, it really runs the gamut. And one of the things we're really big on at DJC is what could we build instead? what could we dream up that really looks like community safety and doesn't involve over-policing and over-incarceration. And so with that, I will turn it over to Ms. Linda Franks.
Excuse me. Good evening, everyone. My name is Linda Franks, and I am with the East Baton Rouge Parish Prison Reform Coalition. We are a group of concerned and affected citizens who have come together in collaboration with other criminal justice reform coalitions in our community to exact a positive change. That looks like closing down the East Baton Rouge Parish Prison, which we have found to be an inhumane place for people who are in a pretrial stance. We are also working to educate our community on how the criminal justice system works, the injustice system works, and how they can best navigate through that. We're also working with our national partners on bail litigation and efforts to end the incarceration of people due to poverty, and to bring an awareness also on decriminalization of certain offenses, as well as putting forth information to help those who have been caught in this system and their families to be able to regain their lives and to be able to navigate through seeing what that looks like, as well as reimagining also what public safety looks like for our community, and definitely dealing with budgets and how those resources can best be allocated to the communities to affect change and to lessen the strife that's going on in the communities today. We do that in a number of ways: community outreach, as well as working collaboratively with other criminal justice reform organizations to really strike at the heart of the issues that are affecting the people in the East Baton Rouge Parish. And we are just so happy to be here, and we are ready to inform you on the ways that you can navigate yourself through this system should you or your loved one find themselves in the grips of this injustice system. Thank you. And now I'm going to turn it over to Mr. Earl Burton.
Thank you. My name is Earl Burton, and I'm the relational organizer for Michigan Liberation. Michigan Liberation is a 501c4 nonprofit organization whose mission is to end mass incarceration. It's important to note that being a 501c4 gives us the ability to endorse in the electoral races. Michigan Liberation has supporters and partners and are leading the work on prosecutorial accountability. In Oakland County, we have the ACLU supporting our work, and along with our team in Wayne County, we bring a coalition of statewide and national groups that support us, like Mass Lib, Working Family Parties, and the Movement Voter Project. Although we engage in many campaigns, this is the flagship campaign of Michigan Liberation because we know the power the prosecutor has, and the lives of many of our base have been affected by the decisions and actions of the prosecutor. Michigan Liberation is the voice of the community of those who have been directly impacted by the criminal justice system. And it's very important to bring the community's voice, especially in the prosecutor races. It is also important to have that voice when endorsing a candidate for prosecutor. What we plan to do is have an impact on the prosecutor race, is doing voter engagement through digital canvassing, Outvote, which is a voter texting program that I'll be running, that I did run during this last election cycle, public education on prosecutor races, and digital and social media. We will continue to build up coalitions with groups to share our vision for the next prosecutor. We're hosting our Oakland County Prosecutor Candidate Forum with the ACLU of Michigan and Working Family Parties. And we ask that you all support us in our work, and I'm happy to be here. And with that, I'll pass it to Shantae Parker.
Make sure I unmute. Good evening. I'm Shantae Parker, Managing Director of the Neighborhood Defender Service of Detroit. The Neighborhood Defender Service of Detroit is a public defender office based in Wayne County. The Sixth Amendment to the United States Constitution guarantees that every person accused of a crime has the right to a lawyer. And a public defender is a lawyer who is assigned to represent someone who is charged with the crime, but who cannot afford to hire an attorney. At NDS Detroit, we provide client-centered holistic representation. And that holistic representation means that we see our clients as whole people, not just a criminal case. We work to understand who the client is and what issues they may be facing outside of that criminal case, like housing insecurity or the threat of immigration detention or deportation, for example. The Neighborhood Defender Service of Detroit opened its doors in October of 2019 to bring the highest quality representation to people in Detroit and in Wayne County. This office builds on 30 years of experience from our office in Harlem, where NDS first opened its doors and introduced a community-based model for providing public defense. Since our inception, NDS Detroit has represented thousands of clients, many of whom are Black people in Detroit. So we understand the racial justice implications within the criminal legal system. We are honored to represent our clients and excited to inspire better representation for all people in Wayne County.
Sorry, the mute button's gonna get us all night. Thank you everyone for being here. I'm super excited to hear from you. I'm proud to work with you. I just wanna also highlight that in addition to the work that we wanna do to support people who are navigating the criminal legal system and the work that we're doing to dismantle oppressive systems of mass incarceration, I'm really glad to hear the reminder from partners that we're also seeking to imagine a better world and better ways for dealing with challenges that we come across as people living in the world. And so one thing that I would encourage people to do as they watch and as they work to address these issues is to also be thinking about the world that you want to live in and what are some alternatives to the systems that we currently have that can be built and empowered by people living in the communities that we seek to serve. And with that, I will turn it over to my colleague, Chris Bufford, who will be moderating our conversation tonight.
Good evening, everyone. My name is Chris Bufford, and I go by he, him pronouns, and I'm a campaign strategist with the Advancement Project. Super excited to be here this evening and moderate this conversation that we'll be having. So I'll be asking our panelists a series of questions, and they'll all respond to those questions. And so the first person is going to be Erin. And the question for you, Erin, is if someone has been arrested, what should they do or say to the police?
All right. Thank you for the question, Chris. So for starters, I think in terms of investigating that question, what do we do when we've been arrested, or what should we or shouldn't say? I think it's important to know the difference between when you've been stopped and when you've been arrested. So we're going to go on a very brief and succinct know your rights journey. Okay. So what's the difference between a stop, a frisk, and an arrest? Well, police can stop you when they have reasonable articulable suspicion, which is a clear and specific belief based on the circumstances that you are presently engaged in criminal activity, have just committed a criminal act, or are about to commit a criminal act. Factors that may justify a stop include a culmination of things. So it can't just be one of these things. Running away, the time of day, your closeness to a crime scene, your likeness to a specific description of a suspect, officers' observations of you exchanging money that they perceive to be, or exchanging something they perceive to be drugs for money, things like that. What is important about that is when you've been stopped, you can know that by saying, am I free to leave? If the officer says no, you know you've been stopped. Now, a frisk, people often hear the term stop and frisk used together, but a frisk requires something separate. For a frisk, police can pat down the outer portions of your clothes with an open hand to see if you are armed with a weapon. They should not manipulate or shake your pockets just to see what is inside. They should not open your pockets unless they can plainly feel a weapon or drugs through their frisk of your outer clothing. But notably, you can only be frisked when an officer has reasonable articulable suspicion, that same term, that you are armed and dangerous, that you are armed, that you have a weapon. This means police should only perform a frisk if they have a reason to believe you have a weapon, such as a bulge from your pocket, waistband, or view of a gun. Suspecting that you have drugs or have committed other criminality is not a valid reason for a frisk, okay? Now, what changes a stop and frisk or stop or frisk to an arrest? Okay, this is really important. The following may change a stop to an arrest: the use of handcuffs, transport to a police station, drawn guns, lengthiness of a stop. So if you've been held for a long time, your inability to leave, invasive questioning, or of course, those famous Miranda warnings that you have the right to remain silent, okay? When can I be arrested without a warrant? A warrantless arrest is lawful when there is, this is another key term, probable cause to believe that you are committing a crime or have just committed a crime. Probable cause is a standard higher than reasonable suspicion, but less than absolute certainty. For example, if officers smell illegal substances on your clothes, they think they see you committing a crime, or see an illegal object in plain view in your possession, they may have probable cause to arrest you. Now, to answer your specific question, what should I do if I am arrested? If you're arrested, you have the right to remain silent, but you must claim this right, okay? You can't just be silent. To claim this right, you should say, I want to remain silent, and then stop talking. So if you start talking again, that can kind of waive that right temporarily. So you want to make sure you say, I want to remain silent, and then stop talking. If you're arrested, you have a right to an attorney, and you should request one immediately. If you ask for a lawyer, all police questioning has to end immediately. Constitutionally, it's required. So to claim this right, you should say, I want a lawyer. I want it now. I want a lawyer. You want to make it very clear that you want a lawyer. There's been cases where people sometimes, courts have interpreted that term all types of way. A guy said, I want a lawyer, dog, and they claimed that wasn't a clear invocation of his right to a lawyer or his desire for a lawyer, okay? Now, notably, last thing, police are allowed to search you at the time of your arrest. A search allows them to reach into your pockets to make sure you aren't armed or to see if evidence of the crime might be there. It also allows them to search your immediate surroundings to ensure there aren't a weapon within your reach. Lastly, if you're arrested in a car, it allows the police to search areas of the vehicle where evidence related to that particular crime might be hidden, or areas of the vehicle within your reach where there might be a weapon. But this only rarely, and again, I want to stress this, rarely includes the trunk. So what happens a lot of the time is an officer will say, can I check your pockets? And you think that you're being arrested, so you think you have to consent to a search, okay? It's always best, because sometimes officers wear body camera, to just, at the beginning, once you feel like it's leading to an arrest, to just go ahead and say, I don't consent to a search. Even if you're wrong and they search you anyway, this enables your public defender to throw out any types of arguments the police might make that you somehow consented to them searching you. So again, just to recap, the three important things, if you take nothing away from what I just said: I do not consent to a search, I want to remain silent, I want a lawyer. Those are the most important things. And the very last point, there's a difference between knowing your rights and showing your rights. Again, I'll say that again. There's the difference between knowing your rights and showing your rights. The difference is, when you know your rights, you have these things, you have this knowledge in your mind, so you know when your rights are being violated. You know when police are using excessive force. You know when they're searching you without consent. But you don't want to show your rights, because that's why we have so many situations where it leads to a dangerous encounter with police. And by no means am I justifying police who use excessive force. We've seen so many killings of unarmed Black people, even if they are armed, legally armed. There's no justification, in my view, for the loss of life. But I want, in informing people and empowering people, for them to know, when you know your rights, you can go tell your public defender after. You can go tell your person who's representing you. You have, the ability to advocate for yourself. When you show your rights, sometimes it can lead to more dangerous interactions. So with that, I will conclude my little question. So thank you for listening.
Thank you so much, Erin. Thank you so much. Great. So want to remind folks, if folks have questions, comments, please drop them in the comments section. And at the end, we'll have time for to answer some of those questions. My next question is going to go to Linda Franks. And the question for you, Linda, is if someone I care about has been arrested, how do I find out which law enforcement agency arrested them?
Thank you, Chris, for that question. And one of the things that I would like for the people who are listening that are in Louisiana, and specifically in East Baton Rouge Parish Prison, to know that they may not have known, is that there are 32 different law enforcement agencies here, just in this area alone. So being able to identify which particular agency has arrested or detained your loved one is very, very important. However, there's something that we may need to broach upon before we get there. Just as we got that great information from Erin in that first question, unfortunately, in these day and times, sometimes we may need to set up a protocol, so to speak, for if we finding ourselves getting stopped. There are a couple of apps that we can that people can assess. I know Siri on our iPhones, people who are iPhone users can access the shortcut pulled over by police app that is now available, as well as legal equalizers for those people who may have a different phone. And those apps can help you in the event that you're being pulled over. You can utilize those apps to map out your location and maybe to notify a couple of contacts that you have in fact been pulled over. Because, the time after someone has been arrested is very scary and confusing. And one of the things that you will want to know is which law enforcement agency made the arrest. In some communities, there are multiple policing agencies, among them state police, federal law enforcement, ICE, city police, county sheriffs. And once you know which agency has taken the person, you can better identify where they may be in custody. Sheriffs are public officials. They're elected by the county or the parish and have a group of law enforcement officers that they oversee. Additionally, in many communities, the sheriff alone manages the local jail in the county and is responsible for managing the day-to-day operations of the local detention facilities. Now, if your loved one is arrested by ICE, ICE stands for the Immigration and Customs Enforcement. This is a federal agency that targets immigrant populations and frequently detains undocumented people. They often have relationships with local policing agencies and sheriffs to build cases for deportation and capture and remove people from the United States. Your local police, most communities have a local police department, and they are usually led by a chief who is appointed by the mayor or other government official. Many police departments have multiple units that address different issues. Some police officers are also assigned specific areas to patrol and monitor. Campus police, for those of us who are in municipalities that have universities and different things of that nature, you can be accosted by the campus police. And in some communities with the large college or university, these officers have the power to arrest and detain people, and often work with local policing agencies to bring charges and incarcerate people. School resource officers, also called SROs, are police that work in schools. While not explicitly called police, they usually have the power to restrain and detain students and report and recommend that criminal charges be brought against young people in schools. They also use their powers to search students and confiscate and dispose of their learnings. Some of the ways that we have in our coalition, some of the ways that we've done is just by empowering and educating our people on what these different municipalities do, what their phone numbers are, what their policy and procedures are, and by reaching out and directly asking them, if someone is detained by you, what is the procedure and protocol? And that way we can empower our communities to be able to better find out where their loved one may have been taken. But it's also a good idea to have this information in hand before you yourself find yourself in a situation and you know exactly who has pulled you over, who is asking you questions, and where exactly you're going to be detained. But thank you for that question, Chris.
Yes, yes. And Linda, I have another question for you. And that question is there a way to find out where my loved one was taken?
Well, that can be tricky, Chris. What I will tell you, in some cities, there's a central booking location, and this is where most people are taken. Other places, local police take people to the closest precinct before taking them to a central booking. In smaller towns, a person might be held in a small local jail connected to the police station. So knowing, again, let me reiterate that knowing which agency detained the person will help you to locate them. And going back to having that system in place. And we definitely want to focus on that. Having that system in place so that your contacts, some of these apps will even have GPS. And so, you know, if you're in East Baton Rouge Parish, and you're traveling to work in Ascension Parish, you may pass through so many different municipalities just in the course of going to work. So sometimes knowing which location your loved one was actually picked up in is going to help best for you to begin that search. Because I will let you know from personal experience that no one is going to call and give you this information. You've definitely got to be proactive. And that is why it is so important, just as we do fire drills, just as we do different things to prepare ourselves for calamity, that we are taking and educating ourselves beforehand so that we are not caught off guard. The East Baton Rouge Parish Prison Reform Coalition, again, let me reiterate that we actually call these different municipalities, seek out what their practices are, and try in our best way to make sure that we are informing our constituents and our public on what is the best way, because most of the time, by the time we're called, someone is already detained, and now we're in a frenzy. And so we really want to make sure that, you know, we're even preparing ourselves for what we think could be the unimaginable.
Thank you so much, Linda, and thank you for all the work that you all are doing. My next question is going to be for Shantae with NDS Detroit. And the question I have for you, Shantae, is how soon after someone is arrested do they get a lawyer?
Good question, Chris. This question is really, the answer is going to really depend on where you are in this country. In some places, after a person is taken to central booking and processed, they are taken to court and immediately assigned an attorney. In other places, a person can be incarcerated for a period of days before they are brought to court and assigned an attorney. Constitutional law does require that a person be assigned an attorney once they are formally charged with a crime. And that's according to the Sixth Amendment right to counsel, as I mentioned earlier. Now in Detroit, attorneys are assigned to represent people generally at their initial arraignment on the warrant. And that's going to be usually a day or so after the arrest. That attorney will make arguments for the person's release from custody or ask for a reasonable bond amount. Before the next court date, though, a different attorney may be assigned to a person if they are arrested in Wayne County. In other places where I have worked as a public defender, like in New York and in New Orleans, an attorney is assigned at arraignment, usually within 36 hours of arrest. In those places, the attorney you meet at your first court appearance is likely going to be the same person who will represent you throughout the entire length of your case. One thing to remember, though, is that the first time you meet with your lawyer should not and likely will not be the only time you meet with your lawyer during your case. So don't panic. You're going to have time to meet with your lawyer again, and you should meet and talk with your lawyer many, many times to prepare your case.
Shantae, I have a follow-up question for you. So say someone has, a loved one that has a public defender and they're nervous or fearful that the public defender isn't doing everything they can to fight for that person. What can they do?
Yeah, that's a common question that I get because public defenders have a reputation for being, public pretenders, attorneys who aren't going to fight for you. And what I know is that that is not always the case. Public defenders can do a wonderful job for their clients. And I want folks to remember that no matter who is representing you in a criminal case, whether it's a lawyer whom you or your family has paid, or a lawyer who is assigned to represent you by the court or whatever system you're in. That could be a public defender like myself, or an assigned counsel, a private attorney who takes assigned cases. They work for you. They are there to assist you in your defense, to help you achieve whatever goals you have for the representation, and to help you fight the case. So I want everybody to feel empowered to engage with your lawyer because, again, they work for you. You should feel confident about their representation and feel good about what they are doing on your behalf. Now, the question is, how do you do that? Two things. One, ask questions. This is going to help you understand what is going on in the process. Here's some questions that you should certainly ask. What am I being charged with? How much time am I facing? What evidence does the prosecutor have against me? What defenses are available to me in this kind of case? Is there a plea offer in the case that the prosecutor has made? What is that plea offer? And what are the consequences of me taking such a plea? How's that going to change my life if I take this plea? What things will I be unable to do once I take this plea? So that's just some questions to ask right out of the gate. And your attorney should try to answer those questions to the best of their ability. If not, they're not working for you. Sometimes, though, they may not have a lot of time to answer those questions if it's the first time you're meeting them. So try to write them down and ask them those questions at another time. Anything that comes across your mind that you're concerned about, write it down and ask them. And I want you to, again, I'm going to say this again, be empowered to ask those questions and get the answers that help you make the best decisions for you. And my second tip, share information. Your lawyer can only help you if they have all of the information about you and your case. So tell your attorney everything. And it's okay to do this because there is a rule called the attorney-client privilege. The attorney-client privilege is a rule that says that communications, right, things that you tell your attorney are confidential, they're private, and they must stay between the lawyer and the client until you say otherwise. Under this rule, lawyers may not, shall not, cannot share their clients' secrets, the information that they share, and nor may other people, like the judge, the police, or prosecutors, force your attorney to share that information. The purpose of this rule is so that it encourages you to be open and honest with your attorney, to share as much information as possible, and that allows your attorney to provide effective representation to you.
Thank you so much for that, Shantae. My next question is, in the courtroom, what happens in there? What should people expect?
Good question, Chris. These are great questions tonight. Depending on the jurisdiction, again, it's going to depend on where you are in this country and the type of charges that you are facing. You may have a preliminary hearing in addition to that initial appearance where your bail is set or you're released. Here, the prosecution must establish that there is probable cause to believe that you have committed the crime. Now, probable cause means that there is a reasonable basis for believing that a crime may have been committed. Sometimes this hearing is going to be at the same time as your arraignment, but if required, this hearing must occur within 10 days of arraignment if the defendant, the person charged, is in custody, or within 20 days if the person is not in custody. An arraignment is a formal hearing where you, the accused person, will hear the charges against you. For misdemeanors, this is usually enough to bring the formal charges. Now, a misdemeanor is a crime punishable by up to 1 year in jail. For felonies, which are a little bit more serious, the process for bringing charges may, again, be more complicated. A felony is any charge that is punishable by more than 1 year in jail. In certain cases, depending on your location and the type of crime charged, there will be a grand jury determination in order for the case to move forward. Now, grand jury is something we hear about a lot. It is a jury, usually a group of citizens who come together, who are empowered by law to conduct legal proceedings, to investigate potential criminal conduct, and to determine whether criminal charges should be brought. Often, this occurs instead of a preliminary hearing in some jurisdictions. A grand jury decides whether to indict or to proceed with the charges against the person. And indict is a fancy word that means just to bring formal charges.
Thank you so much. Thank you so much. And Miss Linda, I know that you all have like a court watch project in East Baton Rouge. Could you talk a little bit about that?
Yes, of course. It has been an invaluable tool in our efforts to really learn and to educate our community on just how the criminal justice system is working here, what to expect when you go to trial. And what it also afforded us was an opportunity to really see who and what type of charges are coming through the courts. You know, there's always been a push to brand certain things as being, you know, for public safety and different things of that nature. But when you really have an opportunity to go into the court and to see just how things are coming about, it will definitely enlighten you to just what type of charges are being filed, how the process works, and just where you can go in and affect the most change. For Court Watch, we are able to go in at what is called here in in East Baton Rouge Parish is the call out, and that is your first appearance. Now, one thing I will tell you is at that time, it is not the time to litigate your case. And if you have not, it is definitely the time that you want to express your need and desire for a lawyer. One of the things that we have found is that even if you feel your family may be able to afford a private attorney, we would suggest that you go ahead and align yourself with a public defender at that time. Sometimes you're not aware of what your family resources may be to be able to retain a lawyer for you at that time. And so by having a public defender at least be coming in to be able to interview you and to get the facts of your case, sometimes it can definitely help to shorten the duration, or even they may be able to advocate for a bail or a smaller bail or bail reduction at that time. It is not the time for you to speak out about what you feel the police may or may not have done. In other words, don't talk about what happened, because at that point in time, you are giving them information that you don't want to give. And so Court Watch allowed us to be a part of that process, to sit in to see how the judges were assessing bail, to see how the public offenders were being assigned, to see what charges were being drawn up and what types of bail were being assessed. And so it was an invaluable tool for our coalition to be able to then go in and to form, for lack of better word, relationships with the judiciary to make sure that we were there to see what was going on. Also, it allowed us to be able to see if there were any people who had medical issues going on at that time. And we could direct the courts to see that this person was in need of some further assistance, of maybe some obvious mental health issues that may be going on or anything of that nature. So having a court watch in this area, and be aware that, you know, courts are, you can go in and sit down and look at court proceedings. They are open. They are your courts. They are our courts. So we are made to be welcome in those forums. And it is very much empowering for you to go in and have a firsthand view just how these types of things are operated and work. Definitely. So Court Watch has definitely been invaluable for us as a coalition to be able to encourage, uplift, and to empower our community when it comes to these first appearances.
Thank you, Miss Linda. Thank you, Shantae, for those wonderful answers. For my next question, I want to go to Earl. And Earl, can you talk to us a little bit about what is bail and what happens if my loved one has bail set, but they can't afford to pay it?
Right. Thank you, Chris. I'd love to answer that question. First thing, you and your lawyer should always ask for release, because if the court does not set a bail, then they'll release you on what's known as personal recognizance. That means that if you are released in exchange for a promise to return to court. Now, bail is an amount of cash paid directly to the court in order to be released, while bond is when a person or a third party, usually a bondsman, pays a percentage of the bill and takes on the potential of additional civil or criminal penalties if you fail to appear back in court. Now, judges will set bail based on a number of factors, depending on the jurisdiction, including flight risk or risk that the person who will not appear at further court dates, and dangerousness, which is the judge's opinion of how likely they are to commit a crime if they are released into the community. If release is denied, the judge will set bail to keep the person incarcerated during their case if they do not have the money to pay for their freedom. If a person is remanded, this means that there is no amount of money that they can pay for their freedom. In recent years, many lawsuits have been brought around the country to challenge unconstitutional bail practices. The United States Constitution prohibits people from being held in jail pretrial simply because they are too poor to pay for their freedom. The judge hearing the case is required to make an inquiry into the accused person's ability to pay, and also whether jailing them pretrial serves a compelling government interest. There should be an inquiry into whether alternatives to incarceration can be identified to ensure that the person returns to court. Sadly, some people are trapped in jail because they can't come up with amounts as small as $250 to secure their release. Whether it's for a few days or a few years, the impact of being incarcerated can have a catastrophic impact on someone's life, including the loss of employment, housing, family separation, and serious mental and physical health impacts. Now, we have a lot of experience with bailing people out of jail. We had what was known as the Black Mother's Day bailout, where we were bailing out mothers who were in jail simply because they did not have the ability to pay. I want to share a story of one particular case that we had. The first day we were doing the Mother's Day bailouts, we got there at like 9 o'clock in the morning, and we were there for 11 hours, because bailing someone out is not like going to the grocery store and paying for grocery. You know, a lot of times there are other warrants that have to be taken care of, fines, fees, tellers, and a host of other costs that's associated with getting a person released. Well, we had this one woman call us as we were leaving. We had been there for 11 hours. It was 8 o'clock, and we were worn out and ready to go. And as we were pulling out of the driveway, we got a phone call from a woman, and she had got our number from another young mother that we had bailed out. And she wanted to know if we could do anything to help her. Well, like I said, we were exhausted. We had been there 11 hours. So without making any promises, we told her to give us her family contact information. We contact her family and see if there was something that could be done. So we called her mother. Her mother was at work at the time that we called her. She could not afford to do anything to help get her young daughter out of jail because her brother had just been killed the day before, and they were trying to raise money to pay for the funeral. So she asked us, she said she was going on a lunch break in 10 minutes. Could we still wait and, meet her on her lunch break? So we said, sure, what's 10 more minutes? So we waited, and she came on her lunch break, and she left us with $20 because that was all that she had. And that moved us so much till we immediately turned that car around, drove back to the jail, bonded that young mother out, and made sure she got home safely. That led to our Court Watch program. And to reiterate what it said, we learned so much by going into court. We were in one particular jurisdiction where it was outrageous. We came up with a term. We were calling it court-sanctioned extortion, because there was criminalizing poverty. This one particular jurisdiction, without naming it, they were like a practice of sitting along the border between Detroit and the suburbs, and they were targeting older cars, which were mainly Black people who they figured didn't have insurance or something else. And we went and started court watching. And this was in a city where the population was less than 10% Black. But what we found out was 80% of the people that went before the bar were people of color. And we just thought that that was so wrong till we made a presentation to the County Board of Commissioners. And they were so shocked by our findings that the State Court Administrator's Office asked for our statistics. They wanted to take a look at it. Well, the judge in that jurisdiction that night decided that he was going to retire for medical reasons. So yes, we have a court watch program that also led to another program that we're involved with, which is called participatory defense, which is like Shantae was saying earlier, where we try to advocate on the person's behalf. We will tell them what their rights are in court. We will try to work with their attorneys. We'll do a social bio. We'll try to, petition the judge to, let the people back out into the community. So Michigan Liberation has done a lot of work with the bail fund, and I can't wait to get back to doing it again. We're still bailing people out, but with the COVID-19, we had to move our timeline up, and we went from bailing just Black mothers out to bailing out anyone that we could to reduce the population, to slow the spread of COVID. So basically, that's our work experience around, cash bail. We're working to get it eliminated, and hopefully, we'll be able to do that.
Thank you so much, Earl, for sharing about this amazing, important work that you all are doing. We'll also want to hear from a couple of other folks about this. So Inez would love to hear about the work that you all are doing.
Yeah, I would love to tell you all about it. Because I'm representing both Arch City Defenders and Close the Workhouse, I'm going to talk a little bit about both. Back in 2018, Arch City Defenders filed a federal lawsuit against St. Louis City judges and St. Louis City for failing to hold constitutional bail hearings for people. We have a mass incarceration problem, not just in our city, but all over the country, and cash bail helps contribute to that. Cash bail is absolutely, it absolutely criminalizes poverty. And in St. Louis, we have a huge poverty problem. After Arch City Defenders filed that lawsuit, I believe it was 2018. In 2019, there was a ruling from a federal judge that told St. Louis City, the way you have been doing bail hearings is trash, and there needs to be a constitutional standard for doing that. And within, that first week after that federal judge made that ruling, 700 people that were being detained inside of both the Workhouse in St. Louis and CJC, who had not received constitutional bail hearings. The judge required that the city hold up to 30 bail hearings a day until those over 600 people who had not received hearings had one. In the first week alone, 187 people had a bail hearing. Out of that 187 people, 119 were released from jail on their own recognizance. Just basically the judge asking, what can you afford? And actually going through the process of a constitutional hearing, 119 people got out of jail in that first week alone. And so the city was pretty mad at us, but they did it. And lots of people were able to be free to fight their cases from home, which is what the Constitution requires. And then on the on the Close the Workhouse side, our role in bail has been really educating the public about what bail actually is. Bail is not about safety. It isn't. It doesn't matter how many propaganda shows that you watch that have brainwashed us into believing that bail is about safety. Bail is not about safety. Bail is about making sure that you come back to court. That is it. Because by definition, if you were not safe to be on the streets, you would not be given a bail. So if you've been given a bail, that means you're not a danger to society. You're not a danger to the community. So that means you should be able to fight your cases from home. So I personally have spent thousands of hours really just trying to get the people of the St. Louis region to, one, humanize people that are inside of jails. The people that are inside of jails, they're not these crazy criminals. More than likely, these are people who are poor and committing crimes, what we call crimes of poverty, in order to survive. So thousands of hours just trying to humanize people. And then another 1,000 hours just talking to people about bail and what it's truly supposed to be about. Again, not about safety. It's about ensuring that you come back to court. Luckily for St. Louis, the Bail Project, which is a national organization, does have a St. Louis chapter. And in the last 3.5 years that the Close the Workhouse campaign has existed and partnered with the Bail Project, they have bailed out over 3,500 people in 3 years. And when they go through and they look at their numbers of that 3,500 some odd people, 92% of people show up to court to have their case adjudicated. That right there should show not just St. Louis, but the whole country that, people don't necessarily need to have skin in the game, because the Bail Project bailed those people. They didn't put their own money in. All they needed to show up and adjudicate their case was, one, a court reminder, like, hey, don't forget you have court on Tuesday. And two, they needed a ride. So whether that meant we were calling an Uber for them, or we got one of our court watch volunteers to give them a ride, or we gave them bus tickets, 92% of people showed up to fight their case. So again, it's not about safety, it's about access and resources and getting a reminder. Who among us hasn't forgotten about a court date, right? Who among us hasn't forgotten about it?
Yeah, I know I've forgotten about it a couple of times. But thank you so much for the work that you all are doing. Really, really important. And so now I want to pass it to Miriam, my colleague, to talk about the important litigation that they are doing around bail in East Baton Rouge.
Thanks so much, Chris, and thanks everyone for listening and for having me here. I'm so honored to be on this amazing panel with all of these fantastic advocates. I'm so honored to work with Inez and her team and CTW with their bail work and on the lawsuit there. But I'm here today to talk about our work in East Baton Rouge and the bail lawsuit that we have there. We've been working with the East Baton Rouge Parish Prison Reform Coalition for several years. And as part of that work recently, particularly during the pandemic, we started to see a lot of problems with bail that have been going on for years and years in Baton Rouge. We talked to people in the jail who had $200,000 bonds for $4,000 worth of check fraud. The person said, I can pay this off. I have the money to repay what I did, but I can't get out of jail to do it because I can't afford this insanely high bond. So we started watching, as Ms. Linda talked about, we started watching court and getting transcripts from court and seeing that these initial call-out hearings that Ms. Linda talked about were absolutely not constitutional. In those hearings, an individual appears in a room from the jail surrounded by sheriff's deputies, and is on TV, talks to the judge on closed circuit TV. And the judge asks the person their name, asks the person their address, tells the person their charges, and tells the person their bond. There's no discussion of whether this individual is a danger to the community, is a flight risk, whether this person can pay their bond. The only time the judge will ask anything about money is to determine if he or she can appoint the public defender to represent that individual. There's no attorney present for these individuals at their hearings. They have to, and often they're not even allowed to speak. When they ask for a bond reduction or try to share that they don't have the funds to afford their bond, the judge will silence them and tell them that he'll increase their bond. He or she will increase their bond if they keep talking. This is an incredibly punitive and scary system, and it's deeply, deeply flawed and against the Constitution. What makes it even worse is that oftentimes people are held for weeks, months before they're able to see an attorney or go before the court again to have their case heard and to argue that their bail is too high. So we filed suit in December in Baton Rouge to try to highlight these issues and seeking to make changes to the system and make the officials who are elected by their communities actually respond to the laws that their communities require them to respond to, like the Constitution. As Earl noted, this is incredibly important. Everyone thinks of bail as kind of not a big deal. People who are stuck in jail awaiting trial on their cases suffer many, many severe collateral consequences. Numerous studies have shown that people who are trapped in jail prior to their trial have worse outcomes in their criminal cases by a statistically significant amount. They're not able to be in the community to present their own defense. They're not able to work with their attorneys as closely. They're limited in their ability to call their attorneys or see their attorneys by the jail's rules or the lines to access the phones for a 15-minute limited phone call, many of which are recorded and cost money. In addition, they lose sight of they often lose their housing, their cars, their jobs. If they have sole custody of children, they can lose custody of their children. They lose connections to family and friends, and really struggle to build back those important connections and assets in the community when they get back out. And compounding that these days, as we've all heard way too much about, is the COVID pandemic. Individuals who are trapped in congregate facilities like jails can be up to a seven-time elevated risk of contracting COVID from the surrounding community. And many individuals who are trapped in jails have medical vulnerabilities that render COVID very serious for them, including diabetes and high blood pressure. So we have taken this very, very seriously. This stage of a criminal proceeding can change someone's life. And as we've learned in East Baton Rouge, where 44 people have died since 2012 in the jail, it can end someone's life. The jail itself is in shambles. I went to see it myself last year and was horrified. The medical expert that I went with for that trip described it as the worst jail he's ever seen in his entire 16-year career in correctional medicine. So places like this do not need to be holding people. There's a presumption that in our system of government and in our Constitution, there's a presumption that people are innocent until they are proven guilty, and there's a presumption that they should be in the community until that determination of guilt has been assessed. That's not happening in Baton Rouge. It's not happening in a lot of communities around this country, and we need to draw attention to that and change it. So that's what our lawsuit does. We're trying to change the system and get people out of these terrible, terrible facilities. Thank you so much.
Thank you, Miriam. Thank you all. I really appreciate all the work that you all are doing and for your responses. And so throughout this conversation, we've kind of gone from arrest and kind of worked our way through the system. And so for this last question, I want to bring back up Shantae, and I want to talk about what takes place between arrest and the trial.
Let me make sure to unmute. So between that arrest and the initial hearings that I've talked about, the arraignment, preliminary examination, maybe a grand jury testimony, and the trial, there may be a long period of time. Cases may last for quite a while, sometimes years. During this phase, the defense and the prosecution are building their cases by interviewing witnesses and collecting evidence. You have the right to a speedy trial. Over 90% of criminal convictions, though, result from plea bargaining, which means that they never get to a trial. I'm gonna say that again, over 90% of cases end in a plea rather than a trial. A plea deal can occur at any time during this entire process. And a guilty plea means that the accused is admitting their guilt, while a plea of no contest, sometimes it's called nolo contendere, means that the person who's accused is not contesting the charges, but is not admitting guilt. With a guilty plea, the prosecutor makes an offer to the accused person and their lawyer that includes some conditions to end the case. There are lots of different types of guilty pleas. Some pleas will result in jail or prison time, and others may provide alternatives to incarceration to keep folks out of jail. And that means they're going to have to do something other than go to jail or prison to end the case. Now, what are those other things? It could be a program, community service, payment of a fine or restitution, or some other steps that the person must take to avoid incarceration. Sometimes there is a plea that's called a conditional plea, and this is where the accused person must do certain things in order to get the offer. And those are called the conditions, which is why it's called a conditional plea. In many cases, people are offered probation, which can be an alternative to jail or prison, but it's still a requirement. It's not easy. Probation is where someone may not be incarcerated, but must follow strict rules and be monitored by the court and or a probation officer, sometimes both, to make sure that they are following the conditions that have been placed on them, that they've been assigned. Probation can be very stressful, right? And challenging because there's so many things that you have to do. And on top of that, it can be expensive because there are fees that are attached to being placed on probation. We're going to talk a lot more about probation in session 3 of this series. But just so you know, that's what probation is. When we think about a plea, a guilty plea, it must be made knowingly, intelligently, and voluntarily. Those are 3 requirements of the law. This means that the person who's charged must understand all the consequences of accepting the plea and should not feel coerced or forced into doing so. And a person, you really should ask your lawyer as many questions, as many times as you need to ensure that you fully understand what you're agreeing to, and also what all the consequences of taking a plea and having a criminal conviction on your record will be for you.
Thank you so much, Shantae. Appreciate that response. And so for our next question, I want to go back to Inez, and I would love for you to talk about what will happen if someone can't get out of jail before their case ends.
If someone is detained pre-trial and can't afford to pay their bail, they will literally just have to stay in jail until the final resolution of their case. The case will either end with a trial where the jury decides a verdict after hearing evidence from both sides, or a judge reaches a verdict in a bench trial. If the person decides to take a plea, the case will be over after they reach an agreement with the prosecutor and the court called a plea agreement. In St. Louis, as it relates to the Workhouse, through the 4 years that this campaign has existed and all of the research that we've done, first of all, the Workhouse is a living, breathing monument to white supremacy and racism in our city. And at Arch City Defenders and the Close the Workhouse campaign, we treat it as such. When we go back and we look at the number of cases, the number of people that are being held over pre-trial, what we have learned is that in the Workhouse, in a city that is about 50% Black, St. Louis is 50% Black, but The population of the workhouse is 90% Black. If that doesn't say white supremacy and racism, I don't know what does. But we have found when people are not given a bail that they can afford and they are left to languish in jail, people will plead guilty to things that they have not done in order to get out of that hellhole jail. The workhouse is infested with rats and roaches. It's got black mold growing on the walls. There is no air conditioning there in the summer. There's very little heat in the winter because there's asbestos in the boilers. And I'm not telling you what I heard, I'm telling you what I know, because in 2016, I spent 30 consecutive days inside of the workhouse. And every single thing I just told you about those conditions are things that I have literally seen and lived for myself. It is my lived experience. So people will plead guilty to things that they didn't do just to get out of that facility. We've also learned that on average, Black people who haven't been able to get out of jail on bail spend 100 days longer inside of the workhouse than people of other racial groups do. Think about that. Spending 100 additional days inside of a facility that's infested with rats and roaches, that the water smells funny, the showers don't work, the toilets don't flush, all of those things simply because you are Black. So if that doesn't say racism and white supremacy, I really don't know what does. Our city defenders and Close the Workhouse, we try to combat the racist policies put into practice that allows the workhouse to continue to thrive. ACD, as a holistic legal advocacy org, does the things to try to stop people before they get to CJC or they get to the workhouse. That means direct representation on their muni court cases, their traffic tickets, getting warrants recalled, helping people with their child support cases. Anything that missing a court date could cause someone to end up in jail, we do those things. We also do impact litigation. That's where the big, huge civil rights cases come from. The federal lawsuit against St. Louis City for their unconstitutional bail practices, the lawsuit against St. Louis City and the people who run the workhouse for the inhumane, unconstitutional conditions that people are forced to live in there. We have social workers at Arch City Defenders that put people in touch with the resources that they need. So when we say holistic, that's what we mean. Keeping people out of jail, getting people out of jail, and then giving them the resources that they need. I am a person who can attest firsthand. I'm an impacted person. I ended up in the workhouse in 2016 because after my ex-husband picked up a hot skillet off of a stove and burned me all over my body with it, and I did what they said you were supposed to do. I left him, and with my 4 kids, I couldn't afford my childcare bill. I was paying $1,600 a month for childcare. I couldn't afford it. So I stole unemployment benefits in order to pay, my childcare bill so I wouldn't have to go back to the man who did this to me. So I was put on probation. I was on probation for 7 years. I couldn't get a job. I couldn't get access to resources because I had a criminal background. And so the work that we do is very personal to me. This is a life that I have actually lived. I am the person that we're all talking about. And I've learned over these last 4 to 5 years that there are thousands of people in my city alone who are living within those same circumstances. I did everything right. I applied for childcare assistance. I made too much money. You know how much money I made too much? $57. Too much to get some help with my childcare bills. which caused me to commit a crime. My choices were commit a crime or go back to the man who did this to me. And all these years later, 10 years later, if I had to do it all over again, I would do the same thing. The thing is, I should have never had to make that choice. I should have never had to make that very, very difficult choice that I would go back and make again. And the reason I had to make that choice is because this idea of re-envisioning public safety. Like, what do we need to divest from in order to invest in us? I want to be invested in. I deserve to be invested in. My neighborhood deserves to be invested in. My city deserves to be invested in. And what can we take money from to put into people like me, to put into my neighborhood and my city? And when we've looked at the numbers, I've personally looked at the numbers, our whole city knows, not just St. Louis, but almost every major city around this country, the bulk of our budget money is going toward police and jails. In St. Louis, 53% of our budget goes to police and locking people up and the courts. That is it. That is it. We give so much money to the police and jails in St. Louis that our health department is underfunded, which having a fully functioning and funded health department during a global pandemic would be nice. And a story I like to tell a lot is in St. Louis, every single year, we are #1 for chlamydia and gonorrhea outbreaks. Every single year. And do you know why that is? Because you can't even go to the health department in St. Louis and get tested for STDs anymore because the budget has been shrunk by 75%. 75%. The health department in St. Louis gets less than $1 million every year, while the police get $250 million. Oh, I'm sorry. The police, courts, and jails get $250 million. The SLMPD gets about $150 million every year, while the health department gets $900,000. We don't have a single walk-in clinic for people dealing with drug addiction. We don't have a single walk-in home shelter for the unhoused community in our city. Could that possibly be because we're spending $250 million on the wrong thing? I think so. And so all the work that we do at Arch City Defenders and the Close the Workhouse campaign is all about representing people to keep them out of jail, giving them the resources that they need, that they never have to think about committing a crime in order to survive. And 3, who can we take money from so that we can invest in ourselves?
Thank you so much, Inez, for sharing your story. Most of all, really appreciate that, and thank you so much for all the work that you do. Yes, thank you so much. And I want to pass it back to Ashley, who's going to take us into questions and answers.
Hi, everyone. Inez, thank you so much for sharing those really powerful words. I'm just still very much thinking about everything that you shared. And I want to just say again, thank you to all of our partners. We're so lucky at AP that we get to work with you all and support your work. I just wanted to first say that for folks watching, there are ways to plug in. Like we said, this is a conversation to empower people who are navigating these systems, but also an opportunity for folks to get involved in their own communities. So I just want to lift up again Miss Linda and all the work that you're leading in East Baton Rouge with the East Baton Rouge Parish Prison Reform Coalition, the Close the Workhouse campaign in St. Louis, and also all of the incredible work that Arch City Defenders are doing in St. Louis. Michigan Liberation, my special partner because I'm from Detroit. I love working with you all and just hearing these experiences, even though I've heard this and I know a lot of these things, it's just really powerful and really moving to hear them. Shantae leading NDS Detroit, our shining beacon of hope for indigent defense, and Erin working at the Detroit Justice Center, which is really helping to lead the charge towards building the world that we want to see. I just, again, want to thank you guys and just let people know who are watching, there are ways to plug in. There are campaigns. These orgs meet regularly. A pandemic can't stop them. There's been like a ton of work that's happened for the past, I mean, it's been years of work, but in the past year, I think a lot of things have really picked up and intensified. And there's definitely ways to plug in. The good news is that we have 2 more sessions. This is just the first part of a 3-part series where we're going to be continuing the conversation. It's also crazy that we haven't even gotten to like trial yet. We only covered policing to pretrial and all this horror that can happen to someone as they navigate the criminal legal system. But we have people on the front lines who are fighting these fights so that we don't have to live like this forever. Our next session will be Thursday, February 18th, where we will focus on trial, sentencing, and plea negotiations. We'll talk about collateral consequences. Like Shantae mentioned, when you have a case, like asking your lawyer, what's going to change for me because of this? Like what's going to happen as a result of this case? So that's session 2. And then session 3, we're going to talk about incarceration, reentry, and more opportunity to talk about dreaming and what's possible. One last thing that I just want to lift up that Inez touched on, but that is like a through line through all of the work that we're doing, is that there are a lot of opportunities for communities to demand something more. And one way to do that is participatory budgeting, which is asking elected officials to start, demanding that elected officials start funding something else, because we know that policing and law enforcement and jails and prisons are failing us. They don't work, and we can no longer invest in things that don't serve us. So with that, I just want to thank everyone for being here. I'm excited to see you in 2 weeks when we pick this conversation back up again. And Leslie, I don't know if you can show the image. One other quick thing I just wanted to lift up is that Earl talked a lot about the bail work that Michigan Liberation has been doing, and there's an incredible bail report that Advancement Project worked on with Michigan Liberation that showcases a lot of the work that's been done, and that also kind of walks through the experience of someone who is directly impacted by the horrible tortures of bail. And so you can check that out on our Advancement Project website. And yeah, so there's that. And then we'll also be rolling out more materials connected to these forums. Because our hope is that people will take the materials that we've created and literally have them in their hands as they're fighting a case, they're arguing with a legislator, the information that you need to feel empowered to continue dismantling and fighting these systems. So that's it from me. I don't think that we had a lot of questions this time. So again, just check out these groups. We're really lucky to support their work. There's litigation that's still going. So hopefully we're on the road to something better.